Hey y'all, welcome back to my channel. If you're new here and you feel like you got a little bit of that common sense that's not so common, go ahead and hit that subscribe button. And if you don't, hit the like button, hit the subscribe button. It's a disease and you'll catch it, I promise, okay? Today on my channel is gonna be another common folk perspective video when we talk about felon voting rights, okay? I feel like it's a good topic to talk about if the highest level of office you can achieve in the United States of America or the divided states of America or United States of corporations, you know, can have a felon in that position, then we should start looking into these felon voting rights, right?
Makes sense to me.
Because all felons should be able to vote at this point. That's what I think, personally, okay? But before we get any deeper, remember, I don't have any law degree, I don't have any law training. I get all my information from good old Dr. Google, then I give it out to you guys with my opinion. But before we get deeper, first and foremost, my name is Key, and this is What's the Key?
For me, work, for me, work the body for me.
All right, y'all, let's get into it. As always, if you see me looking to the right, I'm looking at my notes, and any bell or munching you're hearing is my cat City doing kitty things, okay? Felon voting rights, all right? So I got into this, like I said, if the highest position you can have in this country has a felon in it, then felons should be able to vote, in my personal opinion, at the very minimum. So there are some people who are for felons voting and some who are not for felons voting. The ones who are for it said it's a good way to enhance civil engagement and reduce the likelihood of them repeating their offense and going back. And I agree, okay? When they come out and they get their full rights restored, they have the freedom, okay? That freedom that you want them to feel and want them to hold on to and kind of keep and not go back to jail. When they get that full feeling of freedom, I feel like, honestly, yes, it would make them repeat less. They'll feel like a functional member of society. They won't feel like they're still being held down by their past mistakes, and they won't go back. So I agree with that for the people who are for felons voting. Now, for the people who are against felons voting, it's because they feel allowing felons to vote again will weaken the public's respect for law and order. And I have to disagree with that because I honestly think going into the prison system is already a punishment within itself. They were taken away from society. They didn't have the same freedoms that I was having. They were on a strict schedule. They didn't have all the things that they wanted. So I think that that was a punishment in themselves. Having the felons be incarcerated for that short period of time, to me, is a consequence. Now, I can see a case-by-case basis being for certain crimes, but there's not many crimes I can come with in my head that I feel like should take away a person's voting rights. Or ever permanently at that. Anything I think in my head should permanently take away a voter's rights, okay? Because they still have to be a member in this society. And if they don't feel like they're functioning in this society, then they're more likely to just go back to what they, felt like they were succeeding in more, which is for some people is the prison system. Now, the people who are against also believe that voting is a privilege. I have to disagree with that. I believe voting is right. That you have. You live in this country, you're working a job that pays taxes towards what the government is doing, you should have a say in what the government is doing. So, unless they're going to come out and stop paying taxes towards the government, at this point, they just have to give money to somebody without any say or why. I mean, granted, yes, you're going to say they have the stuff, if any of them are on the public programs or just the cities and stuff. Yes, I get that, but, they should just have some say in some other things if they have to still live around it. Now, in a 2019 study, they showed that only 20% of felons identified as Republicans. That would make a little bit of sense as to why they wanted to keep them, without them voting. If a lot of the ones that are going into being arrested and going into jail are Democrats, then yeah, you got to think about racism, them putting black people in jail, making them felons, boom, now you can't vote. It's an easy way to lower Democratic votes. That I'm just saying, because based off the study, if they say only 20% of them are Republicans, then if Republicans are the main ones pushing back, then that is probably why they don't want them voting. You start allowing felons to vote, you just allowed a big group of people to be allowed to vote again. Now, also in this study, it says that Black Americans make up about 40% of the population that can't vote. Yeah, and when we get into the states that have these additional requirements for people who can't vote or have these absolutely you can never vote again type of requirements, you can see it's stuff that they believe that they can. Let me get down into it. Let's not go any deeper. Okay, that's not right now. Not right now. Okay. So in these places, voting rights are never lost. You got Maine, Vermont, and the District of Columbia. So in those three places, your voting rights are never lost. If you're incarcerated, you can still vote. So now, in these places, your voting rights are automatically restored upon release. And when they say automatically restored, it simply means the prison officials let the voting officials know, hey, this person has been released from prison, isn't eligible to register to vote. They still, in most cases, have to register to vote. So it's not automatic as in, oh, they're getting a voter card in the mail. No. Automatic means the prison officials let the voting officials know, hey, this person can register, no need to deny them anymore. Okay? So these states: California, Colorado, Connecticut, Hawaii, Illinois, Indiana, Maryland, Massachusetts, Michigan, Minnesota, Montana, Nevada, New Hampshire, New Jersey, New Mexico, New York, North Dakota, Ohio, Oregon, Pennsylvania, Rhode Island, Utah, Washington. So those are the states that all have the voting rights automatically stored upon release. So that means if for probation, parole, supervised release, etc., they can still vote on all of that. Now, this next group of states, you have to complete your probation, your release, any fines, any court fees, etc. all have to be taken care of before your rights are restored to vote. Alaska, Arkansas, Georgia, Idaho, Iowa, Kansas, Louisiana, Missouri, Nebraska, North Carolina, Oklahoma, South Carolina, Texas, West Virginia, and Wisconsin. And I'm not going to necessarily see that as terrible that they make people complete their probation and work release and pay their court fines and etc., because in some cases when you do violate probation, your release, you don't pay your fines, you do end up back incarcerated, and then that would just go back into the rule of they can't vote. So I'm not going to necessarily be mad at that. Do I think it's a little extra? Maybe a little bit. Like I said, you want them to feel like they're fully functional members of society. You know, some of these people who were incarcerated, go into halfway houses and things like that, already have a lot of restrictions. So not being able to vote, and let's say they're on probation or parole for like 10 years. So that's a couple elections, a couple major elections, and general elections is even more. Now, these states, we're going to get into the nitty gritty, they all require something additional post-sentencing. So even after they complete their probation, their parole, there's even more they have to do, and it usually involves filling out an application of some sort. Okay, so in Alabama, anyone can file to have a pardon or a certificate of eligibility to register by the Board of Pardons and Paroles. And another person who can give pardons is the governor. Now, they do exclude treason, impeachment, and when the death is imposed and not commuted from ever being able to vote again in Alabama. So I did get this information from MAPS. Remember our movement advancement projects, and they're a little bit more, they liberal. They want everyone to vote, no matter what. It's from what I'm seeing. I'm not seeing, from what I saw on the MAPS website, it didn't seem like they, I get it because they believe in rehabilitation. And if you're saying these people are out and they are, they've been in the prison system, rehabilitated, learned their lesson enough to be out functioning members of society, allow them to have their rights restored. So, okay, I do get it. I get it. Now, in section 1522, okay, in the original section for Alabama, where you'll find this is 17-3-31, but in section 15-22-36, the Board of Pardons or the Certificate of Eligibility can also waive fines as well when they restore their rights to vote. And then each member that is favoring a pardon, a parole, remission of a fine, or forfeiture, or restoration of civil and political rights shall enter in the file his or her reasons in detail, and it will be made public record. So any member on this board that goes, hey, yeah, I think they should have their rights restored, they have to write in letter their details of why they allowed this person to get their rights back, and it is made public record. That's it's a little crazy, but okay, I get it. The pardon must express all civil and political disabilities they want pardoned. The incarcerated person will, what's crazy? They actually say prisoner. in their thing. The prisoner. Like, dang, that's a little... The incarcerated person, well, it is Alabama, will complete at least 3 years of parole unless the end of their sentence was less than 3 years. So they have to complete at least 3 years of their parole before they can file for their pardon unless the sentence is less than that. A pardon based on innocence may be granted with unanimous affirmative vote of the board upon receipt and filing of clear proof and written approval of the judge who tried the case or the DA with written approval of the circuit judge where they were convicted. Now, I'm saying they. Alabama says he or she, and I don't get why they are adamant about saying he or she. Well, we know. But yeah, I just wanted to put that out there. I'm saying they, but they say he or she. I don't understand why even a person who gets their proof of innocence has to even jump through these hoops to get a pardon, to be able to vote again. I feel like just having the innocence, like a unanimous vote. So you're telling me somebody could just say, I don't care that they were shown innocence, I don't want their rights, and they just don't get their rights restored, even if they have the proof of the innocence, even the written approval of the judge who tried the case or the DA and etc. Like that's...
Sound like it makes sense. Does it sound like it makes sense?
A little, they can work on that. They can definitely work on that. Now, there is no power to grant them the right to vote again unless the Attorney General, the judge who presided over the case, the Chief of Police or the Sheriff, the DA who tried the case, same officials of the county where the crime occurred if different from the country of conviction, the Crime Victims Compensation Commission, and the victim, if they request, receive a 30-day notice. Okay? Yes. So the board isn't just, they can't just make these, they have to send all these people I just listed a letter, at least a 30-day notice that this person will have their rights restored to vote. And then they have a few alternatives in place if any of those people are unalived or no longer serving. Now, they have to send them the name of the incarcerated person, the crime they were convicted for, the date of the sentence, the court the conviction occurred in, the sentence that was imposed, the actual time they were held in confinement, and the minimum release date, and that's computed by the Department of Corrections. The action to be considered, so the restoring of the rights, whether that's, we're talking about voting in this case, but that could be firearms as well. Date, time, and location of board meeting, and the right of the victim, the representative of the victim's immediate family, if they are deceased, to let them know that they can present their views to the board in person or writing. And the victim can request not to be notified about this at all. And then after all that is in place, everything gets passed, they can register to vote. So that was good old Alabama, okay? They're definitely one of the worst. For the state of Arizona, if you are a first-time offender, you automatically get your restoration of civil rights restored, and that's in 13-907 in the Arizona Code. Now, this does not apply to firearms. If there was a dangerous or serious offense, and you can go into their statute and see what they can deem a dangerous or serious offense. So for first-time offenders, you can get your voting rights restored in firearms, but in the case that it was a dangerous or serious offense, you cannot have your firearms restored. So I see that. Arizona's like, we'll give you a second chance. Because they don't seem to have a limitation. I didn't see any disqualifying crimes for Arizona. So they're like, we'll give you a second chance. We'll give you a second chance. Now, the court can order the restoration of firearms. So in that case, the courts can waive anything and order, hey, they can have their firearms restored as well. Now, they do in Arizona have to file an application for each felony. Okay, and I'm not sure if the packet I saw maybe had some additional information or stuff in it, but it seemed like all of these applications seemed a little excessive to have to fill out. Like it's a lot. And they cannot file the application no sooner after 2 years of discharge. So in this case, you have to have a 2-year period after you're out of jail where you don't have any of your rights for Arizona. But honestly, if I remember correctly, Arizona seemed like they were like the lesser of two evils. Good old Delaware. Now in Delaware, they cannot register if they had a disqualifying felony. And in this case, it is unaliving someone, manslaughter, except if it's by a vehicle. I don't know why that makes a difference, but I guess it's because The vehicle itself is making the impact, but I'm not sure about that, but it is except for a vehicle. Any felony against a public administrator involving bribery or improper influence or abuse of office and anything similar, and any felony X offenses. Also, if they are convicted of a felony that is not disqualifying, but they have not served their complete sentence, including work release, parole, pain, etc., they cannot be considered full or fully discharged. So in Delaware, they have to fill out an application, everything, but they do have their own disqualifying felonies that once you commit these felonies, there is no going back. Okay? So other than that, you have to fill out an application, you gotta serve all your time, you gotta not convict a lot of these major felonies. I like how Delaware is really onto their like public office and public officials and things like that. Like, no, you ain't gonna be trying to be in here manipulating the legislative and think you finna go out there vote. No, okay? Not too mad at Delaware for that one, for their disqualifying felonies. But I still do believe in second chances, okay? Second chances. Now, Florida. Now, for them, unaliving somebody and X offenses are excluded. So no matter what for them, they are excluded. And then upon completion of their sentence, parole, fines, restitution, etc., they fill out their application, boom, and they get their rights restored. Now, in Kentucky, they're not allowed to vote if the person is convicted in any jurisdiction of treason, bribery in an election, or a felony or a high misdemeanor, as the General Assembly may declare exclusion from suffrage. So with the felony or high misdemeanor, the General Assembly can be like, yeah, because of the crime you committed, you cannot vote. All right. And then also any person that is currently confined at that time cannot vote as well. So they do have to fill out an application. The application, if they, it gets approved, they get granted, blah, then they can register to vote again. Now, in Mississippi, they automatically bar you from voting for any of these disenfranchised crimes. And y'all, we about to get into what racism in Mississippi holding on strong in that. They're holding on strong. I see why the black people in Mississippi go buy their land and disappear and hide off. Now, voter fraud, unaliving someone, raping someone, bribery, theft, carjacking, arson, obtain money or goods under false pretenses, scamming, perjury, forgery, embezzlement, bigamy, armed robbery, extortion, larceny, felony of a bad check, or shoplifting, receiving stolen goods. That's correct. Receiving stolen goods. What if they didn't know? Robbery, timber, larceny, unlawful taking of a motor vehicle, statutory rape, and larceny under lease or a rental agreement. Now, completion of the sentence and application or pardon from the governor or equivalent is required. For 30 days, they must publish about the application. So they either have to have a completion of their sentence and an application filled out, or a pardon from the governor or the equivalent in order to restore their rights to revote again. Now, for 30 days, they must publish about the application and why they deserve a pardon. So publish in your good old local newspapers, etc. I ever wonder if you go to the city, if you just go in a certain section and you see it's a pardon section, and you just read a bunch of people saying, hey, I'm applying for this is why I deserve it, etc., etc. And I wonder if somebody can read it and be like, no, I don't agree, and just fight it back, and then they just wouldn't give it to them. I just real curious about that one. And then they also have to get a 2/3 vote from both houses. And then when they receive all that, then they can restore their rights to vote. Now, they had 2 federal court cases that went against their disenfranchised crimes, okay? One of them stated that they were disproportionate towards black people, which, in a lot of them cases, I know in an article I read, it said that crimes that black people are most likely to commit. In my mind, those are crimes that you can easily frame black people for, even the neighbor, etc. That's what it was giving to me. Receiving stolen goods, robbery, armed robbery, shoplifting, a felony shoplifting, theft. Some of these things you gotta look at like, okay, the punishment is a little bit cruel. compared to what the actual crime is. Now, I granted they may be doing this to try to limit crime, but I'll just make a harsher prison sentence instead of permanently taking away the right to vote for some of these. And the second one stated it was for cruel and unusual punishment, but the federal courts just pretty much was like, no, it's okay. It's fine. Mississippi can do what they want and have these crimes that, are disproportionate towards Black people.
Death to all of them.
And are cruel. Like, a person's rights shouldn't be taken away forever over... And my thing is there age on this? Or can you do this as a juvenile and then you could just never vote when you turn 18? Or is this once you're 18? That's a question I have. Okay, I might have to go look that up after this. In Mississippi, do you have to be 18 for these disenfranchised crimes? Or if you do any of these as a minor, then all of a sudden you can't vote in the state of Mississippi. Ever. Now, in the South Dakota, up until 2012, it was automatic restoral of rights upon termination of sentence. So once they got out of jail, they did their parole, probation, whatever, work release, etc., paid their fines, they still have their rights automatically restored up until 2012. Now, on June 1st, 2012 is when it all changed. They have to get either a standard pardon, which can apply immediately, but as a rule of thumb, the board applies a 5-year eligibility waiting period.
The ghetto!
So they can vie for a standard pardon, but as a rule of thumb, they do a 5-year waiting period, although they can apply for it immediately.
Okay. Whatever that means.
Is that supposed to make them feel better that they can just apply for it immediately when they still have to wait 5 years? Is it a 5-year waiting period for once they got out? Is it a 5-year waiting period from once the application is received? What's up with this 5-year waiting period? And then it's a rule of thumb, not even like a set in law, like they have to. It's just a rule of thumb. Now, an exceptional pardon is the same that I just stated, except it's for first felony and misdemeanors. They are excluded from the publication requirement, which I'm going to talk about in a sec, and they still have to have that 5-year waiting period. Now, South Dakota was the first state to allow them to have online forms. Okay, why waste your time going into a court when you got to wait 5 years anyway? But they were the first state to have an online process for this, and that was on May 18th, 2017. But you can file the forms whether in person or online. Now, the person who is applying for the pardon must publish notice of their intent in the public newspaper of the county that the conviction occurred in, and notify the state's attorney in that county as well. They have to do this once a week for 3 weeks, the last one being the 20 days before their hearing. I wonder if they have to pay for all this, or if it's like an automatic. All right. A letter of personal plea must be submitted stating why they are seeking pardon, and there are no fees to apply, but they may incur fees to complete. Like I said with the newspaper thing, I'm pretty sure they ain't letting you post it for free. That's easy money for them. They have to go to an initial and final hearing, and then the board sends the recommendations to the governor in writing. So there is an expedited process, okay? And it can be for people who commit misdemeanors, a class 2 or a petty misdemeanor, after 5 years after it's been committed, and also for a nonviolent class 1 after 10 years. And this also applies to traffic offenses. Firearms cannot be expedited, so restoring your rights for firearms cannot be expedited. And there is no 2-tier screening, so that just means that the initial screening they go to, from that one screening, they can recommend to the board from the initial panel. And this expedited process takes 30 to 60 days. So an expedited process, after they wait 5 years and 10 years, they can apply to this, get one hearing, be recommended, and the whole process takes about 30 to 60 days. So Tennessee derives rights to people convicted of infamous crimes. Now, for convictions on or after May 18th, 1981, there's a 2-step process. They must receive a pardon or restoration of full rights, which is done by a petition in court, and must pay restitution and court costs, including child support, all before they can submit their application for restoring their rights. The rights will be restored upon completion of sentence, including all their supervision. Now, you are never eligible after June 1st, 1986, if you committed voter fraud, treason, first degree unaliving, and aggravated rape. Now, you're never eligible after June 1st, 1996 if you committed voter fraud, treason, and any degree of unaliving someone or rape. I like how they just, every year they're like, we need to put that on there. And they just saw one person commit a crime. They were like, it didn't fit and you shouldn't have your rights anymore. Now, after June 1st, 2006, you're not eligible if there was voter fraud, treason, any degree of rape and unaliving someone, felonies involving bribery, misconduct involving public officials and employees, or interference with government operations, X offenses, or violent X offenses where a victim was a minor. So, if you do any of that, you are ineligible to ever vote in the state of Tennessee. If you did it all after 2006. So if you did some of that before 2006, all right, you good. You're good. Now, if you were convicted of anything between January 15th, 1973 and May 17th, 1981, you're eligible. What happened? What happened? They just gave a whole period, random days. They were like, anything from that time to any time, you're eligible. What happened? Racism? Something was going on in the correctional facilities? I want to know what happened. Now, prior to January 15, 1973, you still have the right to vote as long as these crimes were not committed. Abusing a female child, arsons and felonies with burning, bigamy, bribery, burglary, bigamy again, felon is breaking into a business house, outhouse and dwelling house, larceny, horse stealing. That's not about right, Nashville. Horse stealing, robbery, perjury, buggery, great sodomy, I don't think I'm supposed to say that, destroying a will, forgery, counterfeiting, receiving stolen property. There go that receiving stolen property again. Incest, and there's a few other things that they listed out. So, as long as you didn't do any of that in 1970, before 1973, or, you know, the name of these crimes probably have changed over the years, and that's probably why they have these specific names written out so that you can look at your specific records and be like, hey, oh, okay, I did that, I can't do that. So, yeah, you still have the right to vote, as long as it wasn't any of those crimes. Two more, y'all. Virginia. Now, Virginia, no one with a felony can vote unless rights are restored by the governor or another appropriate authority. It gets reviewed by the Secretary of Commonwealth. The Constitution of Virginia gives the governor the right to restore rights, but this does not include firearms. The governor is accused of taking his time reviewing it. It's Governor Glenn Youngkin, you know, picture here. And they are Republican. This was suggested by the NAACP, but it was ultimately dismissed. And he states his priority is to non-violent crimes. I get it, but like, you know, we got to get some numbers. How many pardons are you doing every year? Are you denying it, or are people just waiting? Because that's the difference too. Are people just waiting all this time, or are people being denied? Or are, you know, NAACP after, are some of these people with non-violent crimes still waiting just as long? Questions that need answers, Governor Glenn Youngkin. Questions that need answers. Last one, Wyoming. Now, for first-time non-violent offenders, they get their voting rights restored after the completion of their sentence. If they have been discharged from Wyoming's Department of Corrections custody or supervision before January 1st, 2010, or have a non-violent felonies, including out-of-state and federal offenses, they can apply. Now, again, what happened before 2010? That y'all just all of a sudden give all these people just the okay. You know what? It could be anything. It doesn't even have to be something that's necessarily bad against the Department of Corrections or DOC or anything like that. It could be, maybe there were a group of palm-colored rioters who technically had a felony charge, but they didn't want that whole group to miss out on voting, so they just said before 2010. You know, it could be any. I'm just making different random creative perspectives over here. Okay, just like if it was the Sixers, they say all of a sudden make a law, okay, but if it didn't happen before so and so, but you looking at them side eyes, but the Sixers did all that before the so and so. That's the way. But those are the states that require anything additional outside of it. You see that, who was it? Mississippi, South Dakota, and Alabama were pretty much the harshest in this case. Mississippi over there a little racist, and then you got South Dakota wanting you to make sure you fully embarrass yourself. I ain't mad at it. I ain't mad at it. To be honest, I think if that happened ever in like in the county or something I think I'd read them. I'll read them. Like, oh, what you do? What you getting pardoned for? You know, just to see, you know. I truly believe in second chances. And you also want to kind of see what they say. You know, because they have to put their reason for why they deserve the pardon. So I kind of, you know, I want to see what they say. How their growth, because they're going to tell a lot of their achievements, things that they did, accomplishments that they had while they were incarcerated or on parole or stuff like that, or since they've been paroled. So I like to see how you've become a functional member of society after being a menace. But y'all, that's all I have. Let me know y'all thoughts in the comments. The question that I really have is, do you feel like the rights should just automatically be restored? Do you feel like there's any reason a person should never be able to vote, whether they're incarcerated, whether they're in parole, okay, whether they committed a serious or a dangerous crime? Do you feel like there is any limitations? And if you do feel like there's at least some things that you feel like a person should have their voting rights taken away for, let me know down in the comments, okay? I'll talk to y'all later. Bye.
For me, break, for me, break the body for me.